Advisor, helping you finance the way home.
Good afternoon, everyone. Rob Miller here, Provisor Incorporated, your mortgage professional. I am here today with Dara Johnson Tracy, owner and attorney with Horn & Johnson here in Madison, Wisconsin. Welcome, Dara. So, Dara, tell me just a little bit about your background, where you came from, and how you got into estate planning.
Sure. So I'm Dara Johnson Tracy of Horn & Johnson, and I actually started my legal career back in 1994 when I went to work as a paralegal for a general practitioner down in Texas, which is where I'm from. And that's where I found my passion for the law, but I also realized that I'm not a litigator. And so then in 1998, I moved to Madison, and I went to work as a paralegal still for a prominent estate planning firm here in town. And that's where I discovered my passion for death, disability, and taxes. And so there was a 10-year period where I worked full-time during the day as a paralegal, and I went to school at night. But the beauty is, by the end of those 10 years, when I graduated from Marquette Law School in 2008, I was able to hit the ground running because I knew exactly what I wanted to practice, and I had 14 years of experience as a paralegal. And I have been dedicated to death, disability, and taxes since then. In 2013, my law partner and I opened up as Horn & Johnson, and we're on the far west side of Madison. And all we do is estate planning, probate when someone passes away, and also guardianship if people become incapacitated and require a guardian.
So you mentioned that you're here in Madison. Where primarily do you practice? Is it just in Wisconsin, or do you have other states that you practice in?
It is only in Wisconsin. I am a Wisconsin attorney, but many of the things we'll talk about today certainly would apply across the country. You just have to make sure and check with an attorney who practices law in your state.
So if I have a customer who is in northern Wisconsin, Wausau, you have no problem working with them even though you're here in Madison?
That is correct. Yeah, we can always find a way to make it happen.
Awesome. That's great. So tell me, we talked about estate planning. Tell me, what is estate planning? What makes up estate planning?
Sure. So there are lots of common misconceptions about estate planning. The first most common thing that I see is people think they have to have a whole lot of money to even worry about estate planning, but that couldn't be further from the truth. If you think about it, you could be worth zero and still need someone to make your health care decisions and manage, your bank account and Social Security payments. So estate planning truly is for everyone. Everyone over the age of 18 should have something in place. And so I'm just going to briefly go over some examples of documents everyone should have. And this is, whether you're 20 or 90, unless you can guarantee me you're never going to die or become incapacitated, we do need to cover some basics. So for example, of course, you need to have a will or a revocable living trust, depending on your circumstances. But the will is a death document, so it doesn't do you any good if you became mentally incapacitated. So in addition, you should have a comprehensive financial power of attorney designating someone to make financial decisions for you. And this is true even for spouses. In Wisconsin, for example, if you own property jointly with your spouse and you became incapacitated, you couldn't even sell that property without going to court unless you had a comprehensive financial power of attorney. So it's important for everyone, and especially if you have real estate. Plus, of course, you need healthcare documents. You need a healthcare power of attorney designating someone to make healthcare decisions. Again, in Wisconsin, your spouse does not automatically have the ability to do that. HIPAA authorization, where you designate a list of people who can call the hospital and get information. And funeral planning, right? So there's an authorization for final disposition that we have in Wisconsin where you can designate the one who you trust to follow through with your wishes. So those are some examples of essential estate planning documents everyone should have in place. So as you can see, estate planning isn't simply just filling out a will, right? And also every family is different. Some people have blended families, some people are married, some people are unmarried, some people have minor children, some people don't have any children. And so regardless of your circumstances, you need something, but again, be careful with fill in the blank documents.
Okay, thank you very much. It's good information. Why is estate planning important for people when they own properties, specifically
Sure.
real estate?
Yep. And so You can name beneficiaries, for example, on bank accounts through payable on death beneficiary designations. You can name beneficiaries on investments through transfer on death beneficiary designations for most institutions, not all. And with real estate, you can name a beneficiary on a deed through what we call a transfer on death deed, which would avoid probate, and you can designate somebody who would inherit your real estate if you die. But you have to be very careful with that, because let's say you have 3 children, for example, and you name those 3 children in equal shares as beneficiaries on your transfer on death deed. Well, now if you die, you have 3 people owning one piece of property, which means they all have to agree on the sale price, they all have to agree on the realtor, and maybe one of them is a basement dweller still living there, right, and has no interest in getting the house ready for sale. So you have to be very careful with those strategies. A much better option is to have a comprehensive estate plan in place as opposed to just a transfer on death deed, where you designate the child or whoever else is going to be responsible for selling the real estate, choosing the realtor, making sure all the final debts and expenses get paid, and then dividing the assets among your beneficiaries as you direct. So you can truly simplify that. Now, the other issue with real estate is in Wisconsin, if you die owning more than a total value of $50,000 in your name without a direct beneficiary attached, you have to go through a probate proceeding if you have a will, right? Even if you have a will. And that's another misconception about estate planning, is if I have a will, I don't have to worry about it, right? Well, no. If you're depending on your will to transfer your assets when you're gone, the only way to execute the provisions of that will is through a death probate proceeding. It's not the end of the world, right? But it is a pain for whoever's in charge, because I'll just say whenever we're in court, whenever there's a court proceeding, nothing happens quickly or cheaply. That's simply the nature of the beast, right? So on average, a probate takes about a year, just because there's a lot of paperwork we have to get through. We have to notify your creditors through a notice in the newspaper. And just for the pleasure of using the probate system, the courts charge us $2 per thousand in Wisconsin. And that doesn't include the attorney's fees or the filing fees or any other publication expenses and other out-of-pocket expenses. So it's expensive, and then it's in the end it's public, because we have open records laws in Wisconsin. And again, probate is a court proceeding. So somebody could type in your child's name, see exactly how much they inherited through the probate process, names, addresses, it's all out there. And so when you have real estate, we already talked about the possibility of the transfer on death deed, but for many people that's not going to be an effective solution. You can build a revocable living trust and place your real estate inside of that trust and avoid the entire court proceeding.
Tell me a little bit about owning properties in multiple states and how it impacts probate.
Sure. So if you own property in more than one state, so let's say you own properties in several states, then the probate proceeding I was talking about will be multiplied, right? So you'd have to have your primary probate proceeding in the state in which you reside, and then you'd have to have an ancillary probate proceeding in every other state in which you own real estate. So if it didn't sound nice to have a probate proceeding in Wisconsin and try 2 or 3 going on at the same time with multiple attorneys across the country, it can get pretty messy. But that's where, if you have a revocable living trust, you can place all of your properties into that trust and avoid all of the court proceedings with regard to the real estate.
Yeah, it sounds very expensive as well.
Yes.
So another question that I think of is, owning a property and you yourself become incapacitated, where you are maybe older and you have to go into a nursing home. Tell me a little bit about how that impacts nursing home, paying for the nursing home.
Sure. So in Wisconsin, if you need to go to a nursing home, then you must pay for your own care until you spend down your assets for Medicaid qualification. If you're unmarried, you have to spend down your assets to $2,000. And so we have trusts that are available, irrevocable trusts, to protect your real estate. So for example, I have a client, she was in her 70s at the time. She was a widow, and her only asset was her home. She owned that home jointly with her husband before he died for many decades. That's where they raised their children. But she knows, she lives on Social Security, that if she has to go to a nursing home, then she's going to have to go on Medicaid. And so what we did was we took her home and we placed it into an irrevocable trust. Now, she can't be the trustee of that trust. Her son is the trustee. but she continues to maintain the right to live there without paying rent, to use the property as she chooses. But once we made it past that 5-year look back period, and you have to make it 5 years from the date we create the trust and place the real estate into the trust. Now it's been about 6 or 7 years. If she has to go to a nursing home at this point, she can immediately qualify for Medicaid, and the home can still pass to her children. If she didn't have that irrevocable trust in place, then she would have had to sell the home and spend down all the assets. We would all go to the nursing home until she got to that $2,000 limit, and then she could go on Medicaid. So there are lots of good options that are available if you plan proactively.
It's amazing stuff. So another thing that I think of in estate planning, and sometimes people don't quite think of. Tell me about having your children as your beneficiary. You're not married, but you have children, whether it's 1, 2, 3, multiple children. Tell me a little bit about them as your beneficiaries to your estate.
Sure. Well, first of all, you never want to name minor children as direct beneficiaries of anything. And here's why. So for example, I have a 9-year-old daughter. And let's say that I named her as a direct beneficiary of a life insurance policy. The way that would play out is if I died then, that life insurance policy nobody could claim it until someone went to court to get appointed legally as her guardian, the guardian of her estate. And that applies even if she has a living parent. That parent then would have to go to court and become her legal guardian. And then the proceeds would be paid to an account that's held by the court. So it's a protected, locked account. And anytime her guardian needed money from that account, they would have to request a new court hearing and explain to the judge why he or she needed the money for my child. And so that can get expensive, of course, because you have to hire an attorney each time. You have to file the proper paperwork with the court, and the courts don't release these funds very easily, right? They're very skeptical. And so a better option might be to have a trust in place for that child, whether it's through your will, a testamentary trust, or built within your revocable living trust. And then we can establish somebody who is the trustee of that trust, who can decide how the assets can be invested in the meantime, what the money can be used for until my child reaches a more reasonable age. And so that's a much better solution if you have minor children.
Another thing that kind of popped into my head is, you talked about having a young child. Well, you pass away and you're not currently married, but you have a biological parent. Tell me a little bit about how trusts can impact and be helpful to use and to help protect your assets from the ex-spouse.
Sure. So in most circumstances, when you have a divorced couple or just a couple that shares a child and they're not together anymore, more than likely you would not want your former spouse to be in charge of your child's inheritance. In most circumstances, we want someone else to be in charge of that money for your child. And so this is where, again, comprehensive estate planning can take care of that, because we can name someone other than the former spouse as the trustee of your child's trust. And that way, although they're more than likely going to raise your child until he or she is 18, they don't have control over the purse strings for your own assets. And so that's a way that we can protect things in a situation like you're describing.
Well, that's just a lot of great information. My head is exploding with information. I want to thank you, Dara, for joining with me today. I hope you enjoyed this current installment of Welcome Home, your video guide to mortgage planning. Please stay tuned for future episodes, and don't forget to subscribe below. Thank you.
Call the provisor.